We want to get back to that Supreme Court ruling. One of two major decisions has already been made and again made public. Again, citing in favor of that Christian website designer that the state cannot force her or any website designer to make their artistry for same-sex couples should they choose. A 6-3 ruling. I want to bring in Randy Zellen. He is a criminal defense attorney and former prosecutor, also an adjunct professor of law at Cornell University School of Law. Good to see you. Thank you again for picking up. I know we talked to you just moments ago. And here we are with this breaking news again. Can you weigh in on this and what you've read so far?
So much for easing into the holiday weekend, but I think the court did it on purpose. This is one where you really, no matter what side you come down on, you better be wearing a crash helmet. I think what the court basically did was say, listen, and I'll borrow from the cake case. I have to sell you a cake. I don't have to put an inscription on it. And I think what happened here was the court, because remember, in the cake case, the court never really reached the constitutional issue and basically said, you know what, these commissioners who decided the case, they weren't neutral. What they said wasn't cool. And that's why they ruled in favor of the baker. Here, the court stepped out from behind the curtain and actually took a constitutional position and said, listen, by making this person create this web design, we are forcing this person to speak. We are forcing this person to express him or herself. And that is something that we're not going to do. So the court really danced between raindrops on the matter of we're not suggesting discrimination. What we're saying is we're not going to make someone express him or herself in a way that is contrary to his or her religious beliefs.
You know, and Randy, this was a private business of Lori Smith's, this website business here. Can you weigh in on how that's significant when it comes to this ruling?
Yes, because we talk about discriminating against members of the public, and there is a difference between selling into the public and choosing not to sell to the public because there is a freedom of choice. I can choose not to provide services to members of the public at large. But if I choose to serve members of the public at large and I choose to allow people to come into my shop, then at that point I am subject to the laws of treating all people fairly and not distinguishing and choosing to whom I do business with based upon the color of his or her skin, the sexual orientation, gender. Those things are frowned upon. But again, here, talk about threading a needle with a microscopic thread. What the court said here, okay, you are doing business with members of the public, but again, we may force you or not allow you not to sell a cake to someone whose sexual orientation you don't agree with, but we're not going to make you celebrate them by writing an inscription that they want you to write on the cake. Here, the web design is the same concept. A web designer is expressing oneself, and the court said by making that person create this web design against their religious belief, we are forcing you to express yourself. We are compelling you to express yourself in creating this design, and that is not what we believe the law was designed to protect against.
All right. Again, 6-3 ruling in favor of that Christian web designer there. The state cannot force her to make, again, a same-sex website. Again, citing First Amendment there. We appreciate it. Randy Zellen, thank you so much, by the way, for answering not once but twice today. We do appreciate that. Now enjoy the weekend, hopefully, for you. We'll bring in Alan Dershowitz here, professor emeritus at Harvard Law, famed constitutional attorney as well, author of several books. Good to see you, Professor. Thanks so much for coming on. We appreciate that. We've been watching many of these cases. Again, still awaiting the student loan, the Biden student loan forgiveness decision. But if you can weigh in on this one, if you would, hear the court 6-3 siding with the Christian web designer.
It's a close case, but it's an extremely dangerous decision. Let's just change the facts a little bit. Let's assume that a religious Catholic has a business and won't serve anybody who's divorced. Would the court have come to the same decision? Or what if you have a fundamentalist who says, look, what about the part of the Bible that talks about the curse of against black people. We're not going to integrate with black people because we have a religious belief. You know, the devil can cite scripture. And in the gay rights case, you know, there'll be substantial support by the public, by a lot of people who are bigoted against gay and lesbian people. But the same rule would apply to somebody who refused to serve divorced people. Let's remember, I'm not a theologian, but the argument against divorce in the Bible is much, much stronger in the New Testament, particularly in the Christian religion, than against adultery and against divorce. And so there are so many things in life that people believe are prohibited or required by the Bible. If we permit the religion to become a license for law breaking, generally, we're going down a very, very slippery slope. Now, you know, obviously I haven't had a chance to read everything, and I hope there are constraints in the decision, because otherwise it can be a very, very, very dangerous slippery slope, allowing people to claim religious excuses for not integrating, for not doing a range of other activities that the law compels.
All right. Again, there's still a lot to wade through. Again, as you were saying there, with the dissenting opinions, et cetera, and that ruling, a lot to read up on there. But we appreciate that. Again, Professor Alan Dershowitz joining us live.